respect to the Missouri court plan as sort of a case study earlier in the year. Before I introduce our moderator, our speaker, I have a few announcements. First of all, thank you to the National Federalist Society for coordinating the technology once again. That works out very well for us, so thank you. I also want to start with an important announcement, just in case you haven't heard this. As many of you know, the founder and former president of the Jeff City chapter, David Welch, passed away earlier this year. Thanks to your generous donations, we have recently made a memorial contribution in his honor to the Federalist Society. David's unwavering support of the organization through that means continues. And by the way, if you missed that, you can probably still make a contribution in his name directly to the Federalist Society. A bit of housekeeping. If you have a question, you can type that into the Q&A box. Professor Blackman, I think, will be watching that. He's going to take.
I am very good with the Q.
Good. Upcoming events, we'll do that now quickly. The next webinar will be on October 21st at 11 a.m. Judge Jeffrey Sutton and Edward Whalen will discuss their forthcoming book, The Essential Scalia on the Constitution, the Courts, and the Rule of Law. Keep an eye on your emails and note the National Lawyers Convention, which will be done remotely, November 9th through 13th. One additional thing I'm going to do right now while I'm still talking, and then I'll bow out, is that many of you remember, you might have gotten an email up for our last CLE about implicit bias, and a note was suggested by one of our members, Judge Daniels, about some changes to the Missouri improved instructions that actually don't use the word implicit bias, they talk about unconscious bias. There are new rules for the civil side and criminal rules. Rather than rattling off those instructions, which will chew up a lot of our precious time, I'm going to cite to you the actual rules, and you should check those out because those will now be used both with the panel and with the jury itself. So the civil rule is 2.00C. It's given to the panel. The rule given to the jury is 2.03A. On the criminal side, you want to look for MAICR 400.02, 402.01, and 402.05. Both of those talk very generally about not being influenced, tell jurors not to be influenced by conscious or unconscious preconceptions or stereotypes based on many, many factors. Those include now gender identity, and sexual orientation. Okay, with that, I will now turn to the introduction of our worthy speaker. Professor Josh Blackman is a professor of law at South Texas College of Law in Houston, and he specializes in constitutional law, the U.S. Supreme Court, and the intersection of law and technology. Josh is the author of 3 books: Unprecedented, The Constitutional Challenge to Obamacare, 2013, Unraveled, Obamacare, Religious Liberty and Executive Power, that's from 2016, and then finally, An Introduction to Constitutional Law, 100 Supreme Court cases everyone should know, and that's from last year. Josh was selected by Forbes magazine to appear in 30 in Law and Policy. He has twice testified before the House Judiciary Committee on the constitutionality of executive action on immigration and health care. He is an adjunct scholar at Cato. Josh is the founder and president of the Harlan Institute and founder of Fantasy Scholar. There he is.
I had to reach off camera to get the prop, and it was a little bit further than I thought it was going to be.
There's the book.
Thank you so much.
How thick it is. Turn it sideways.
It's a very quick read. It's under 400 pages. You can read it in a couple days. It's a very, very quick read.
Okay, very good. So everyone can see that. Get it on Amazon. He's the founder of Fantasy SCOTUS, the Internet's premier Supreme Court fantasy league, if you have any members out there, and blogs at joshblackman.com. As we were discussing earlier, you also see his contributions on the Volokh conspiracy, which you can read his contributions almost every day. He's the author of nearly 6 law review articles, and his commentary has appeared in the New York Times, Wall Street Journal, Washington Post, USA Today, LA Times, and many other national publications, including the Jeff City Tribune. No, I don't know. Okay, with that, I'll turn it over to Joshua.
Thank you so much, Eddie. It's a pleasure to be here. I regret that I can't be with you all in person. I visited Missouri a number of times. I very much enjoy my time there, but unless something magic happens, we're stuck on Zoom for a while. The topic here is Model Rule 8.4G, Implicit Bias, and the First Amendment. I imagine that many of you probably would not want to study this on your own accord, but the powers that be in your benighted state bar have deemed it essential for you to take an hour of training on what's called cultural competency, diversity, inclusion, and implicit bias. Thankfully, the bar hasn't really defined what I have to say about those things. And even more thankfully, they approved my topic, so let's go. I'm going to be critical of those concepts, and I think there's some serious constitutional problems with forcing lawyers to subsume to these trainings. So First Amendment works both ways, I guess. So my goal here is to hit 6 major parts. First, I'd like to focus on ABA Rule 8.4G. This rule gives the state the power to discipline conduct related to the practice of law for speech that can be deemed harassment. Lectures given at CLE events like this one, I'm engaging in the practice of law right now, you didn't know, but I am, are covered. Were any of you here in person and you were talking to the person next to you, that conversation at this CLE function would probably also be conduct related to the practice of law. In other words, everything going on here, if you put a line in the chat right now, don't do it, maybe you're afraid, but if you put a line in the chat, you are engaging in conduct related to the practice of law. Congratulations, you didn't even know it, but you are. And if you were to say something or type something that you reasonably should know might be derogatory, I'm using the scare quotes because they're not defined terms, you could be subject to sanction by the bar. This threat of sanction will chill speech on matters of public concern. I don't care. I have tenure, right? Let them come after me. I mean that sincerely. I would love to be a test case for this rule. In fact, Texas is considering it. Bring it on. But most people don't have that luxury, right? Most attorneys have to actually work for a living. They can't just do what I do and just sort of tweet all day. This will chill attorneys in their professional vocations. And the rule and its history show no awareness of this novel intrusion into the private spheres of an attorney's professional life. Okay, so that's the first part I want to talk about. Second, I want to compare Model Rule 8.4G with other rules, as well as state regimes that have been adopted. 8.4G is quite unprecedented. In the past, the bar has tried to discipline the legal practice, conduct before a tribunal, conduct when you're dealing with a witness or a judge. But this rule extends to conduct related to the practice of law. And this sphere has only the most tenuous connection to representation of clients, a lawyer's fitness, or the administration of justice. Third, I want to dive into the chilling effects of 8.4G. Historically, courts have upheld the regulation of attorney speech in the context of the practice of law. Think about regulations of advertising, advertising fees, solicitation, right? There are things that I think the state has been able to regulate in the past. But as the expression becomes more attenuated from the bar's traditional purposes, the state interest becomes far less compelling. So I don't know how much these past precedents really support Rule 8.4G. We also have a couple significant Supreme Court cases that are on point. One called Mattel v. Tam, and the second called Nifla versus Becerra. And these cases, I think, put far more tight restrictions on the state to censor offensive or derogatory speech. Next, I want to walk through a state-by-state overview of where 8.4G stands. The good news is most states have rejected it. The bad news is a handful of states have accepted it, with perhaps some modifications that don't make a terrible difference. Finally, or fifth, I'm going to come to this concept of implicit bias, or maybe subconscious bias, as your state calls it. This is not science. It's not. This is not verifiable. It cannot be replicated. These studies are not very useful. And it's a shame that bars are simply accepting this without any questions, because it's affecting your own jury instructions, right? Your pattern jury instructions are now affected by this. I fear that this will be weaponized against lawyers as a way to get them in trouble for not adhering to certain orthodoxies. We can all agree racism is bad and discrimination should be ended, but we can still have a discussion of what methods are used to go there. This is not a one-sided, do whatever you say type approach. Okay. Finally, I will connect your state bar's discussion of implicit bias and your ethics rules with 8.4G. Preview: 8.4G doesn't prohibit implicit bias. It has a knowing standard. So unless you know what you're doing, you're not breaking the rule. So none of this entire push for 8.4G wouldn't even help with implicit bias because it has a knowing standard. You reasonably should know, right? So I think it's tricky. The second, not to give away the ball game, is that 8.4G specifically approves speech that promotes diversity and inclusion, but it doesn't approve speech that's perhaps critical of diversity measures, which has serious viewpoint discrimination problems. All right. So let's get started. Model Rule 8.4G, I'm going to just read parts of it. I hate PowerPoint, by the way. I will not do it on Zoom. I hate it. But 8.4G makes it misconduct for an attorney to engage in conduct that the lawyer knows or reasonably should know is harassment or discrimination on the basis of race, sex, religion, national origin, ethnicity, disability, age, sexual orientation, gender identity, marital status, or socioeconomic status. I don't even know what that last one even means. Socioeconomic, I know what it means, but it's such a nebulous term. Socioeconomic status in conduct related to practice of law. Okay, that's the rule. Then we get comment number 4. Comment number 4 says, conduct related to the practice of law includes representing clients, interacting with witnesses, coworkers, court personnel, lawyers, and others while engaged in the practice of law. Okay, so far so good. Operating or managing a law firm or law practice. Okay, that's a little bit more attenuated. And here comes the biggie. And participating in bar association, business, or social activities in connection with the practice of law. Now, if the bar had just tried to regulate representing clients and working with witnesses, I wouldn't have that much of an objection. I think when you're in a court, if you're in a tribunal, the state has some interest in making sure you're not doing stupid things. We can argue about that, but I'd have less of an objection. But this last component is really where it gets troubling, because it's not just legal practice, but it's in social activities in connection with the practice of law, which again is this, what you and I are virtually sitting through right now, would be subject to 8.4G. Now, some history. Why was the bar so intent on regulating social activities? The short answer is they were worried about sexual harassment. There were a number of people who testified before these committees and said that, women, female associates were being, sexually harassed in a, limousine ride home from a deposition. Or on a business trip, a senior male partner was propositioning a female associate to come to his hotel room. These sorts of things. And so there's a fear that if you limit this rule to only legal practice, you would allow male partners and male attorneys to continually to sexually harass women. Okay, we can agree that stuff's bad. You could probably craft a more narrowly tailored rule, but that's why they're so intent on going after social activities. They may not be concerned about me up here saying that affirmative action has constitutional problems. I think they're concerned about the harassment, but I do think there are some people in this movement who would be happy with me shutting up. I think that there are some people who would be happy with certain speakers not saying certain topics. I don't think it's a majority, but I think they're there. I've been protested. I've been shouted down. It's happened to me. And I think without question, this is going to be something that will be weaponized. There's actually litigation going on right now concerning 8.4G. The Hamilton Lincoln Law Institute, run by Ted Frank, challenged the Pennsylvania version, which is a variant of it. And they actually have an attorney who works for a civil rights group who speaks on free speech. And he said, I'm a member of the Pennsylvania bar, and I can't do my job because I fear prosecution by the state. So we'll see how that lawsuit goes. I think there's some standing problems, but there are always standing problems in everything. Okay. The model rule is just that. It doesn't bind any states. But now states have been considering it. And for the last 3 years or so, it's been going through the process. I've been pretty active in this process. I filed letters in, almost 20 states opposing this rule. It's a very painful process because there's not always a clear protocol of how states adopt these rules. Sometimes it's very fluid, and in some states, random people can petition the state Supreme Court. In other states, the Supreme Court does it sua sponte. In other states, it goes through committees. It's a very balkanized process. So here's the rundown, and I think my count is accurate, but it changes so often. I might miss a state or two. By my count, 6 states have formally rejected the rule: Arizona, Idaho, Montana, New Hampshire, South Carolina, Tennessee. In 3 states, petitions were submitted to seek comments on it, but the petitions were withdrawn after a comment period. I think they flipped out because of litigation threats. Nevada, Louisiana, and Alaska. In 3 states, the comment period closed, but there's no decision yet. D.C., New Mexico, D.C. is not a state. Well, 2 states and a territory. D.C., New Mexico, and Utah. These ones are suspicious because the bar knows they're going to have fighting to do, and they're just waiting to see what happens, right? They're just sort of letting the petition hang on forever. D.C. will be the huge one because a lot of attorneys who practice for the federal government also keep a D.C. bar membership. And if the D.C. bar adopts this, it would significantly impact the FedSoc membership, significantly, because a lot of them have federal practices in D.C. By my count, 1 state still has an open comment period. It finished recently. Iowa had one open, but it finished. So the Iowa one is done. The Texas Attorney General issued an opinion arguing that 8.4G is unconstitutional. Yet my beloved state bar in Texas is referring to a committee whether to adopt 8.4G. I spoke on a bar meeting. We do it by Zoom now, and I said, if you're doing this, make sure you budget some money for legal fees because you're going to get sued. Right? This is a non-trivial issue. When these states adopt this, there are going to be legal challenges, and the bar has to hire counsel because the Texas AG sure as heck's not going to defend them. So they have to basically pay for it out of our own dues. In fact, I think the Texas AG will sue the Texas bar. Go think about that one for a minute. Can you imagine that the state AG says it's unconstitutional, and they say, no, we'll do it anyway. Yeah, okay, go for it. All right, now we get to the other column. By my count, only 1 state adopted 8.4G in its entirety, which is Vermont. And it was done, I don't want to say quietly because that's misleading, but there was not much of a notice, right? There was a little, if you go through the Bar Journal, which is not available online, it's a print journal, there's a little notice that said, we're seeking comments on this. Just like, one of these little columns right that. No one even noticed it. And they basically just adopted without any opposition. It went through quietly. And again, I don't think it was malicious, but there was no effort to publicize it. So it was just the bare minimum in the Bar Journal. By my count, 3 states have adopted a more narrow version of 8.4G. And when I say more narrow, the differences are not always material. They make changes. They think, oh, if we make this change, it'll be better, and it usually isn't. But there are 3 states by my count. There's New Hampshire, Maine, and Pennsylvania. Pennsylvania is a big one. It's a fairly populous state, far more than New Hampshire and Maine are. And we do have a lot of attorneys there. There is litigation about the Pennsylvania rule. I mentioned it earlier. I'm not sure if a facial challenge works. I just have a little bit of concern. Facial challenges are hard, especially when there's no enforcement action taken. Right, to do a pre-enforcement First Amendment challenge, those are really tough to win. Even putting the merits aside, just in general, Eddie's nodding. His First Amendment, it's hard to win a pre-enforcement facial challenge on the First Amendment with overbreadth. It's hard. So that case may have just jurisdictional hurdles that maybe can't be cleared. I don't know. Why does that matter? If you can't do a pre-enforcement challenge, this rule just sits and lingers and chills. Sort of lingers in the background, waiting for a bar in 5 years to bring an action against you. And that's the bigger risk, that it just sort of sits there and waits, lying around until you have someone gives a speech and they get a bar complaint against them, and then you spend 6 years defending it. Right? That's the risk. All right. That is, I think, where we are right now in terms of the adoption rates in various states. Okay. Now I want to talk for a few minutes about why 8.4G is quite unprecedented. And I don't use that word lightly. I guess I use it way too much. But the rule indeed is novel. We have misconduct rules in the model rules, and they've been around for a long time. But if you look very carefully at the model rules that existed before 8.4G, they were all responsibilities, duties, and restrictions when lawyers are practicing law or representing clients. Right? That was the historical understanding of what the model rules did. They governed the practice of law and when an attorney represents clients. It could be in litigation, it could be transactional, whatever your practice is, that's fine. Family court, criminal court. There was always that connection about the attorney-client relationship, right? About the attorney's role as a counselor, about your duties as an advocate before a tribunal or any forum, how an attorney interacts with people other than a client. You're talking to opposing counsel, right? You're talking to someone you want to solicit, right? There are rules about that. There are rules of how you govern a law firm, right? There's certain things you can't do with confidentiality and fees. There are things you have to focus on. There are rules on your discussion of public service and pro bono, which is something we should all aspire to. There are lots of rules on advertising. There are a lot of rules on advertising solicitation. I don't know in Missouri, but some rules are very stringent of how to solicit and advertise. And generally, if you violate any of these rules, you're subject to discipline. And let's be frank here, the bar doesn't do this very often. There are a lot of really bad lawyers. I don't want to name names, but there are. In every state, there are bad lawyers who don't get punished because the bar simply lacks the resources to go after the bad actors. And that's just supply and demand. You just don't have the resources to do it. So very often a bar complaint will be filed. It might take years to actually go through the process, and then the person gets a censure and loses their license for a couple months, and whatever, they're back. The bar is self-regulated. So I don't think that the concern here is that you'll have people being disciplined for violating 8.4G. I think the bar is smart enough not to try setting up a test case for Josh Blackman. Right? They're not going to come after me because they know I'll fight back. I think the risk here, again, is what's called chilling of speech, where attorneys simply say, you know what, I don't want to risk this. Or even more likely, an associate asks his partner, hey, can I give this speech? And he's like, no, not worth it. Not worth it. We don't want to get clients pissed off. We don't get letters to the bar. And that's it. And then the word's never spoken. So this rule actually acts like this sort of latent threat. Now, many states already have provisions governing bias. Okay? And I want to make this point, I think, very clearly. States, I think, do have a responsibility to address, I'm going to try to say the word actual, but to address actual allegations of improper conduct in the workplace. We have federal discrimination laws, which, thank you, Justice Gorsuch, are broader than they were before, right? Sorry, too soon. The state does have this interest, but the state's bar jurisdiction is not unlimited, right? In most states, the state Supreme Court authorizes a group called the bar, however they want to structure it, to govern the legal practice. And that group is given basically a monopoly on governing the legal practice. There's only one bar in the state. I can't form the alternate Josh Bar of Texas. I can't do that. It's not allowed. But like any other government institution, there's a delegation of power. And that delegation concerns the legal practice. So any regulation from the bar, I think, has to be within the scope of that delegation. And I'll tell you, in state common law, delegation is different than the federal constitution, right? In the federal constitution, Congress do whatever it wants. In state constitutional law, there actually are limits on delegation. So I think some of these states may actually, some of these state bars may actually engage in ultra-virus activity by trying to regulate social activities that are so far attenuated from the legal practice. All right. So by my count, about 36 jurisdictions have amended their Rule 8.4G to prohibit discrimination, harassment, or other forms of bias against certain groups. About 36 states, almost not all, but about more than half. And I think these rules govern three types of conduct. Okay, so the first type of conduct is the most narrow. And the states regulate bias during the representation of a client or in the practice of law. Right? Bias during the representation of a client or in the practice of law. This is the core of what I think the state bar is responsible for. When you're representing a client or practicing law, right? This is going to sweep in the areas that traditionally were subject to state regulation. All right. Second, there are other states that took a more broad standard. This second category regulates bias that implicates a lawyer's fitness to practice law. The lawyer's fitness to practice law, whether or not it occurs in the practice of law. This is only in 2 states, so it's pretty rare. You can see why this becomes a little more problematic. A person's fitness to practice law can be very subjective. We're not just talking about whether they're honest, right, or ethical. This can go to character. And when we're discussing character, there's so much gray area over what certain traits are desirable or undesirable. This one worries me, but this is only in 2 states. Some states have tried to get away with a little bit of a fast and loose one, and they've said, we're prohibiting bias that would prejudice the administration of justice. Bias that would prejudice the administration of justice. We often think of this phrase, administration of justice, but what the heck does it mean? What's justice? I'll tell you, my definition of justice is not the same as other people's definition of justice. And you're giving the bar, these are vague terms to go after attorneys. I think this standard can reach conduct entirely outside the attorney-client relationship. And 7 states have this standard. It sounds really nice, but I think it's actually quite problematic. Still, none of these jurisdictions provide a basis for 8.4G. Right? Most states have more narrow scope. So, for example, Indiana, you have to be engaged in professional conduct. Right? Washington is in connection with the lawyer's professional activities. Okay? But 8.4G specifically says social activities. And I think that's the most dangerous phrase in the entire activity. If they had excluded social activities, I would not be as up in arms, right? Because social activities suggest they're going beyond the lawyer's legal practice into their personal sphere, right? Into their personal sphere. And that's where the First Amendment problems become significant. All right. Next, I want to turn to the constitutional analysis. And I don't have time to talk about the free exercise of religion. Like so precious minutes. But the free exercise claims are significant, especially as social mores change and phrases like religious liberty get scare quotes. I think we're going to see efforts to treat certain religious beliefs as basically white supremacy, call it whatever you will, bigotry, whatever label you want to use. And I can imagine an attorney speaking about his faith at a CLE event, and that is viewed as derogatory. A person discussing his articles of religion, and that itself is viewed as harassing to people that they should know about it. So the Christian Legal Society has done a yeoman's effort to publicize this rule. Kim Colby at CLS has done a wonderful job. Keep in touch with them and just get on their mailing list so that you'll see what's going on in your jurisdiction. But the free exercise issue is significant. I'd like to focus on the free speech issue if I can for a moment. When we talk about constitutional scrutiny, you have these labels: strict scrutiny, intermediate scrutiny. All these labels are not very helpful. The court usually does a sort of balancing act where they look at the means and the ends, right? The means are, what are you doing? What's your regulation, right? What law are you enacting? And the ends is, what are you trying to achieve, right? What's your goal? And then the court says, what's the fit between the means and the ends? If there's a very close connection between what you're doing, what you're trying to do, then usually the law is going to be valid. But if there's a disconnect, it's like, well, you're doing this, how the heck does doing X lead to this result? In that case, there's a weak fit. Okay? There's a weak fit. So let's again think about 8.4G. If the goal of the bar, this is what the bar does, is to regulate the legal profession. When you're actually regulating the legal profession, you're having a close fit. But as you move away from that goal, regulating social life, the fit becomes less tight. Context matters for the First Amendment. Right? We don't have a history of enforcing speech code at social activities. Usually when people are off the clock, they were off the clock, so to speak. Okay? Also, employment law usually doesn't govern social activities. Perhaps if there's a severe or pervasive harassment pattern that spills out of the workplace, you can have some sort of workplace liability. But generally, employment law isn't concerned about what you say at a bar function, unless it has some sort of severe pervasive pattern. I think this is the backdrop that helps make sense of Rule 8.4G, right? As speech bears a weaker and weaker connection to the delivery of legal services, the bar's justification becomes less and less compelling. Okay? Now, the bar, one second. Okay. The 8.4G rule, though, doesn't come across with complete neutrality. It doesn't come across with complete neutrality. Rather, it actually imposes an express viewpoint discrimination. All right? Comment 4 to 8.4G says that lawyers may engage in conduct undertaken to promote diversity and inclusion without violating this rule. I said again, if you speak in favor of diversity and inclusion, you're fine. But if you speak critically of diversity measures, you're not fine. This is the giveaway, right? This is the part of 8.4G where they're telling you what they really think. They're okay with speech that advances their vision of the common good. But if you engage in speech that is critical of their orthodoxy, their ideology, you will be punished. And I can't tell you how significant this 8.4G comment 4 is, right? Your state bar discusses the importance of diversity and inclusion, but criticizing those measures will give rise to discipline, right? That's thought control, right? That's orthodoxy, right? Justice Jackson told us nearly 6 decades ago, if there's any fixed star in our constellation, it's that the government cannot prescribe what's orthodox. Speech in favor of affirmative action is A-OK. Speech that's critical of affirmative action can give rise to disciplinary action. That by itself is why we can't adopt this rule. I mean, that it's such a simple and obvious point that defenders will not recognize because they know it's true. They know that some speech is considered okay because it conforms to their orthodoxies. And in my mind, that's every letter I write to a state bar, I say you have to kill this rule. In other words, if we're going to be on the hook for speech, so are they, right? If people critical of affirmative action be punished, then those advancing it will as well. Because I know there's going to be a right-wing troll somewhere who files a bar complaint at every affirmative action event. It'll happen. I know it's going to happen. In fact, a couple states don't even know what they did. A couple states have, Pennsylvania and others, adopted versions of 8.4G, but they stripped comment 4. So they've just basically made it a disciplinary offense to promote diversity measures. Like, they don't realize what they even did. Like, without comment 4, a person critical of affirmative action can say, you know what? I think it's racist that you're saying we should have racial preferences. That's racist. And you can file a bar complaint. So in their effort to try to placate people like me, they stripped the comment. But then they opened up their own members to liability, right? Which is why this is not a serious process. This is, the bar's going to love this one. This is virtue signaling. It really is. This is going to do very little good, but designed to make it, we're doing something. We're not just sitting tight. We're having the difficult conversations. We're taking care of action. It's virtue signaling. This is going to do very little good, and the potential to do very much bad. All right, now let me give you some examples of CLE topics that I think could give rise to liability. And I have 11. I'll give you maybe most of them, maybe all of them, that's how I feel. Right? So one of the protected categories is race. What if I want to give a CLE presentation on affirmative action and I want to argue mismatch theory? That affirmative action hurts minority students because it places them in a setting where they have a lower chance of success. Oh boy, thermonuclear if I say that, right? I'm not saying it, but if I say that, I could expect a bar complaint. Poor Justice Scalia, in one of his last argued cases, raised mismatch theory, and he got excoriated. What about gender? If I say that women should not be allowed to be eligible for combat duty, that's an opinion. Maybe right, maybe wrong. But that might be viewed as derogatory against women. Let's say disabilities. What if I think that people with mental handicaps should be eligible for the death penalty? It's a position. Supreme Court's taking that question. But that's, I think, demeaning towards people with disabilities. Sexual orientation. What if I say that Obergefell v. Hodges was wrong? The 14th Amendment does not prohibit sexual orientation discrimination. Bar complaint. Oh, here's a good one. What if I say Justice Gorsuch was dead wrong? He was wrong in Bostock. He was dead wrong. I've said it over. Hell, file a bar complaint, YouTube. Go for it. Right? If I say that Justice Bostock was wrong and the Civil Rights Act of 1964 says nothing about Gender identity. Bar complaint. Right? Here's a good one, right? What if I say that people who are on public welfare should receive mandatory drug testing? That's this lingering issue. Guess what? That's socioeconomic status discrimination. Bar complaint. Okay, I just gave you a couple, but these go on and on and on, right? Once you peel back this line between your personal and your professional lives, we're in the business of policing speech. Now, it's no surprise that all the examples I gave were conservative topics. If I'd say why Justice Gorsuch was so awesome in Bostock, no one's going to complain about it because that's pro-gender identity. Right? If I say that Bergeville v. Hodges was the greatest case of the 20th century, there's no bar complaint. Right? If I say that no one should be executed, there's no bar complaint. Right? If I say that affirmative action is awesome, there's no bar complaint. That's comment 4. So all the viewpoints on one side of the political aisle are cool. And all the viewpoints on the other side of the political aisle are triggering, right? They're not okay. And this model basically bakes in progressive approaches to thought. It's thought policing. It's not expressed, but it does have that effect. Again, I don't care because I have tenure in my job, but I recognize full well that most lawyers do not have tenure in their jobs. They can be disciplined, they can lose their job, they can lose clients. And that's why I feel so compelled to speak out against this regime. All right, so let's move on to this topic of implicit bias. Implicit bias. So we know what bias is, right? I'm sure there's some lawyers on here who do employment discrimination law. There are books after books after books defining what bias is in the workplace. There's an established body of case law. But generally, bias requires some form of scienter, some form of intentionality, that you knew what you were doing, or maybe you were acting recklessly, or you intentionally harassed someone. There's some form of intentionality behind this doctrine. Okay? But there's also this concept in the law of discrimination without intent. And historically, this was called disparate impact, right? You had disparate treatment, which is where you intentionally discriminate, and disparate impact, where the court says, well, look at statistics and say, well, there's no evidence of discrimination, but this test, black people do worse on this test than white people, and this is not right. But there's some form of statistical analysis to show that over some large population, a policy was intentionally adopted that had a disparate impact. All right, I'm not going to attack disparate impact. It's completely made up. It's not in the statute, but that's not my theme for today. Implicit bias, I think, goes to a different level. It's not alleging that there was any intentional discrimination. It's not even alleging that there was some sort of structural policy put in place that was well thought through that had unfortunate impacts for certain racial groups. Implicit bias is different. It's this notion that we all have certain prejudices in our mind. We're not aware of them. And those prejudices impact how we live our lives, how we go about interacting with others. And one of the ways that people are supposed to identify these implicit biases is through a test, which some of you may have seen. If you haven't, you may be required to take it. It's called the Harvard University Implicit Bias Test, or IAT. The ABA, Section Litigation, already promotes it. Some bars are now requiring it. The Texas bar is now requiring that its members go through it and that Texas judges go through it. This is catching on like wildfire. We're at an inflection point where it's become just this orthodoxy, and it's not accurate. The IAT does not predict subconscious bias based on a single test. Okay? It doesn't. The results cannot be replicated on multiple administrations. If you take it today and you're in a good mood, and you take it tomorrow and you're kind of sleepy, and you take it on Sunday when you have a headache, you'll get 3 completely different results. All right, so the way the test operates is it shows you words or pictures and it asks you to associate. If you see a black person, do you have to associate positive or negative words with it? If you see a white person, do you associate positive or negative words with it, right? And it times you of how long it takes you to actually come to these conclusions. Not everyone has the same reflexes. For example, I am very bad at video games because my reflexes are terrible. You ever go get an eye exam and you have to click that little button when you see the things flashing in periphery? I fail that test every time because I suck at buttons, right? I'm not trying to brag, but like this is basically almost like a test of how good you are with reflexes. Another problem is that people game it, right? If you're very smart, which I think most of you are, you're able to realize what they're trying to ask you and put the right answer, right? You're able to put what you think they want you to put. So there's a lot of people projecting an image of what they want to convey. I can go on with this for some time, but these are not reliable tests. Maybe if you administer the test to an entire workforce, 1,000 people, right? You can develop some aggregate trends. And I entertain that. That's entirely feasible. But the notion is that you can give it to one person and determine what that one person thinks and use that in any sort of helpful manner is simply false. The state bars are using a technology that is, pardon my French, Missouri bar garbage. It's just not science. It's a shame that you're incorporating this. It's a shame that you're making your attorneys sit through this lecture I'm giving them, but I feel incumbent to do it. I'm not getting invited back next year. But it's true. This is not science. It does not measure implicit bias, and what it does measure does not correlate with discriminatory behavior. So I see I have tenure. My own dean signed a letter to the American Bar Association asking that all law schools give implicit bias testing to their faculty. I told him about it, and I complained the day it happened. I was like, this is not good. The rub, though, is that they're not just giving you the test, but they're going to review your results. That's one that scares me, scares my wits out, right? If they give you these tests and they review your results, and they say, well, you're not up to snuff. You need more training, sensitivity training, or cultural awareness training. At that point, we're going to re-education. We're going down a very bad path when that becomes part of it. If you're just sitting here listening to a person talk, whatever, but it's actually this interactive, engaging, it's thought control. Right? We all do training we don't like. Title IX, you probably do this if you're in education, or Title VII, whatever, right? You're just clicking through. But the implicit bias training is very different. It does not merely seek to convey information. It's designed to extract information and use that information to force a person to reconsider his or her own approach to society. Right? And it may not be enough just to certify that you did it. You may have to submit your results, which might result in counseling, remediation, or re-education, as it's called. I don't know that any states required members yet to do the test, but I know that judges are being required to do it. And I think your results will be used against you in a proceeding. Let's say that someone files a bar complaint against you and say, well, let's see your implicit bias testing. Let's see where you are. These things don't go away when you take these tests, which is why I think fight them where you can. Our society is moving so quickly now. A few years ago, it was unthinkable for athletes to kneel during the national anthem, and now the athletes who stand have to explain themselves. Norms that were once well entrenched are being unsettled rapidly. I get the desire of the bars to address pressing racial issues. We need to be very careful about pushing this flawed social science on people, right? And I don't think it's effective. I think these measures are going to backfire. These are not going to change hearts and minds. Now let me level up a bit. Some of these actual measures I think are unconstitutional. I'm sure you've seen this book, How to Be an Anti-Racist. It's everywhere. This guy named Ibram Kendi, who's on, he's very, very good in the media. He's on every show. And the notion is you can't just be opposed to racism, you have to be anti-racist. And what the hell does anti-racist mean? Let me just read you an excerpt from his book. The only remedy to racist discrimination is anti-racist discrimination. the only remedy to past discrimination is present discrimination. And the only remedy to present discrimination is future discrimination. Now, it's an awful tautology because it uses the words to define himself. It's poor logic, right? But it actually says that to be anti-racist, you have to discriminate against white people. He's very candid about this. That's why these rules, I think, reflect the understanding that some types of discrimination are okay and others aren't. And it bakes it into the analysis, right? Some kinds of implicit bias are fine. Some kinds of explicit bias are fine. The problem is, under current doctrine, this is unconstitutional. Go look at the Chief Justice's opinion in Parents Involved. The way to stop discrimination on the basis of race is to stop discriminating on the basis of race. That doesn't work anymore with the modern approach. Another case that's relevant is City of Richmond versus J.A. Croson Company, right? Past racial discrimination cannot justify rigid racial quotas. In Grutter v. Bollinger, the court says that affirmative action can be used for a narrow purpose, for advancing educational diversity. But some of the ways that these bars are discussing diversity is simply not permitted. I recognize why the state bars are taking these actions. I get it. I truly do get it. But I think they have to be very careful with the First Amendment and to the extent they're regulating speech. I think they have to be very careful about the 14th Amendment to the extent that they're imposing racial preferences. I think they need to be careful about their own jurisdiction. They need to be careful they don't intrude beyond the scope of their statutory authority. That's an easy one to win. Winning the First Amendment's hard, but I can see state courts saying you've gone too far, that this is beyond the scope of your power. I'll end with this word and I'll take some questions, so we're almost out of time. Bar associations resist the urge to stray from the core functions. Not every lawyer wants to be a hero. Some just want to be attorneys, do their job, feed their families, and go home. All right. Thank you very much, and I welcome your questions.
I see that we have a couple of questions already in the Q&A.
Okay, here we go. Okay. Oh, God, Julie. Okay, I'll do Julie's question second. Mark, I promise I'll get to you. Julie's an old friend. Mark asks, expand on why DC's adoption of model rule might impair FedSoc membership. Oh, no, I didn't mean it would impair FedSoc membership. What I meant to say was that a lot of FedSoc members are members of the DC bar just because they work in DC. So this is a rule that would potentially allow the state to go after FedSoc members. We're already seeing that the DC bar is entertaining complaints against the Attorney General William Barr and members of the Trump administration. I think this is going to be a new normal where the way conservative attorneys are shamed is by these frivolous bar complaints, which won't lead anywhere, but they require time and effort to litigate. And, if you're a law firm considering whether to hire someone coming from government, you may say, you know what, I don't want this hanging over our clientele, right? It's many, oh my God, almost a decade ago, you might recall that Paul Clement was the attorney, I think he was at King and Spalding, and he was defending the Defense of Marriage Act, DOMA. And his firm, King and Spalding, said, we can't have you doing this case. You have to drop it. So Paul Clement left the firm, made his own firm. That takes guts, which Paul Clement can do, not everyone can do. So again, all of these concerns are really just chilling. It won't lead to any actual discipline, but it'll shut people up. And that's what scares me the most. My most fervent wish in life, sorry, too soon, is to have people speak their minds and not fear retribution by the government. All right. Julie asks, Josh, can you comment on the future of the conservative legal movement? Yeah, that's a 1-minute question. Let's assume that future office holders do not expand the number of justices in the Supreme Court. All right, I'll do my best, Julie. We're at a precipice right now. If I'd given this talk last week, I would have just complained about John Roberts for a few minutes. He may not matter much anymore. And I don't say that because he's unimportant, but because he's no longer the swing vote. Let's just assume for a moment that President Trump tomorrow nominates Judge Amy Coney Barrett, and let's assume she's confirmed, and let's just assume Trump wins re-election, which makes things easier for the court packing thing, right? The first rule of court packing is you don't talk about court packing, right? And the second rule of court packing is you don't talk about court packing. Basically, you can't talk about it because if you talk about it, then everyone knows what you're going to do. But let's assume Trump wins. At that point, we will have a 6-3, well, on paper, a 6-3 conservative majority. We've had 6 Republican-appointed justices. For a brief period after Justice Thomas's resignation, I think we had two Republican-appointed justices, only 2 Democratic-appointed justices, right? There were not many. So we've had many Republican-appointed justices. The problem is that they weren't very conservative. But here we would actually have a majority of right-of-center judges. And I think what we're going to see is pressure on the... That'd be nice, but we just don't have those. Now, as for the conservative legal movement, if you keep having justices who are Republican-appointed who kind of don't toe the orthodoxy, so to speak, and vote like Gorsuch in the Bostock case, people may get frustrated. Maybe you'll have me back another time to talk about Adrian Vermeule. I'd love to. But I think there is a growing divide in the FedSec membership. And your senator, Josh Hawley, who was one of our members until not too long ago. No, he wasn't? I don't know.
No, I think he is. I think he still is.
No, I meant of your chapter in Missouri. He was a local before he became a senator.
I don't know if he was a dues-paying member or not.
All right. Well,
he has spoken to us before.
Well, I like Josh. I like Senator Hawley. But I think he's articulated a very important position that religious and social conservatives can't be taken for granted in this movement. I don't know where that schism leads, Julie. I'm sorry. Okay. Hopefully that was okay for your question. All right. Other questions? Eddie, did I do all the time I needed? I'm not sure exactly how we're keeping time for the bar, and I don't want you to nitpick me on some sort of stupid technicality.
Well, believe it or not, the bar only requires 50 minutes.
Oh, so, good. I think I'm good then.
We're already into a fraction, although I blew a bunch of time at the outset. So I think we have covered our topic. I wish we had a few more questions, but I don't... Oh, wait, somebody did just ask a question.
All right. Could President Trump... Hawley was on the St. Louis Advisory Board. Well, that's good to know. I've known Josh and his wife Erin for some time. They were both law professors, and so before they were famous, they were just another one of us. Here I am on Zoom, and here's Josh on the Senate floor. So the 2 Joshes. Perhaps President Trump could nominate all FedSec members to the Supreme Court. I think we need a 7,000 member Supreme Court. Basically, the entire FedSec directory is on the Supreme Court. I'm sure Gene can figure that out. And then we could just pick a random panel of 9. I think we'll be okay.
Well, it would be interesting to have a discussion with Professor Vermeule. That could be another.
Good luck getting him. He's not interested, but he doesn't do these things.
Maybe for a different group, but I'll talk about that offline.
Fair enough.
Well, thank you very much, Professor Blackman, for joining us today. Thank you all for listening in, and I think with that, we're all concluded.
Thank you so much, everyone.